I am David Kopel. I'm an adjunct professor of constitutional law at Denver University Stern College of Law, also the research director of the Independence Institute, located just a few blocks from here, that as always all scholars from DU or the Independence Institute testify on their own behalf only. Let me start with two of the technical issues that have come up on this bill. The first one is about the fact that in the attempt to say the maximum capacity of a shotgun is 8 rounds, there is the problem that not all shotgun rounds are of the same size. Some are 3.5 inches long, some are 1.5 inches long. And so a magazine, someone has a magazine for which he, 12-gauge shotgun that holds 8 rounds for the purposes he typically uses it for, but that, and he never thinks of it as holding more than 8 rounds, and that's all the experience he has. But he could be charged under this bill because the magazine, which holds 8 3.5-inch shells, certainly has the ability to hold a larger number of shorter shells, shotgun lengths, shells, as other senators have explained, are not all of a single length. So I was thinking about this while the proponents were speaking, and there actually is a fairly straightforward solution to this. And that is, if you say 8 rounds, 3.5-inch shells, that's 28 inches on the magazine tube. Just make that the rule. The magazine tube can't be more than 28 inches. And then you have 8 rounds for the 3.5 that the person might use, and yes, you could have, and that could hold more for shorter rounds. But then we have something that's very definite. So a person knows exactly what the law is and is not, or what he can do, and doesn't have to worry about whether his magazine is illegal because somebody else could put shorter shells in it, which he never uses. That seems like a straightforward thing, and actually gets the law closer to being something that, even though people may disagree with it, pro or con, at least provides a clearly identifiable standard for citizens to obey and for law enforcement to know what to enforce. A second concern is on this readily convertible issue for handguns and rifles. These magazines are basically rectangular boxes, where they might be slightly curved. The way they work is the magazines are pushed up by a spring that's on the bottom of the magazine, and the spring doesn't touch the bullet, the rounds of ammunition directly. There's sort of a flat plate called the follower that is in between the spring and the ammunition. The problem with readily convertible is if you have, say, a 15-round magazine, you can open it up, that's not a hard thing to do, and snip the spring. The spring will then be shorter and compress further, and then you can put 16 rounds in there. Now, would I ever advise anybody to do that? Definitely not, because that magazine was made to have a spring of a certain size to properly push each round of ammunition up, so you'd be more likely to cause a misfeed, a failure of the magazine. But the danger of the readily convertible language is in those cases where there's a police officer or a prosecutor who has it in for somebody, it makes it possible to bring the charge against that person who had properly, legally, a 15-round magazine. Now, obviously, if you do snip the spring and put in 6 so that it can't put in 16, then you've got a 16-round magazine. That's an actual 16-round magazine under this bill, so no problem with the prosecution under that. The problem is that 15s, and then sometimes even small, even a 13, you snip the magazine enough, it could physically hold 16 or 17. It wouldn't function as well, but it could do that. So I would suggest that as technical corrections, which are still both of those consistent with the spirit and the intent of this bill. There was also discussion early on about what the research has shown. And let me see if I can, and there was a bunch of different studies that came, let me see if I can clarify what they say. When the 1994 federal ban was passed, which banned magazines over 10, part of the compromise to pass that was that it would have a 10-year sunset, and that over the course of the 10 years there would be a federally directed study of the effectiveness of that law. And then Congress at that point in 2004, at the sunset time, could decide whether to renew the ban or not, taking into account partly what the study said. The organization chosen to perform the study was the Urban Institute, which is a well-respected left-leaning think tank in Washington, D.C. It was Jan Marino's Department of Justice that chose the Urban Institute, and I don't think anybody has ever accused Attorney General Marino's Department of Justice of being excessively biased in a pro-gun direction. There were several interim studies, and then the final study was published in 2004 based on the 9 years of data nationwide up through 2003. They found, and I'm talking specifically about the magazine ban in there, they found no statistically discernible evidence that this had saved any lives. And notably, they also found no statistically discernible evidence that it had any effect on gunfights, such as maybe the average numbers of rounds of ammunition fired in a gunfight might have decreased. They looked for that and couldn't find any statistically significant evidence to that effect. That's one of the reasons that this January, another analysis by the National Institute of Justice, which is the research arm of the U.S. Department of Justice, which was, this was supposed to be kept secret, but it got leaked, and it said the magazine ban isn't going to do any good unless you make a major effort to, as they said, buy back the existing supply of magazines, which is to say, we'll have mandatory confiscation and pay people something for their magazines. And I think Senator Hodge and most of Colorado public opinion recognizes what an absolute catastrophe that would be to try to force confiscation at this point. So the question is, is it realistic, based on what the National Institute of Justice has said, to say that this really will be something that will make a difference in saving lives? People have talked about various atrocious crimes and the use of different sized magazines in there. But let's take a look at, and there was a study from Michael Bloomberg's group that began, its first data point was January 2009, which of course is a rather selective and interesting data point, because that's just the right time to avoid Virginia Tech, which happened in 2008. Virginia Tech was the worst. We had, I believe, 32 people murdered there, more than any of the others. There, the murderer had only a 15-round Glock magazine and a 10-round magazine for his Walther pistol. So you could have Virginia Tech here with guns, with magazines that remain legal under this bill. I'm not sure it's really realistic to say that you're going to reduce the death toll when Virginia Tech suggests the opposite. And really what the studies, I will say, I'm not a spokesman for the county sheriffs of Colorado, but I did represent them in the Colorado Supreme Court in the CU Kerry case. And the brief we presented certainly said that the most important thing in reducing the death toll in these attempted mass murders is the response time. How long does it take until there's someone who can start fighting back with a firearm? And when it's 20 minutes, as in Newtown, or longer than that, because the building doors were chained shut at Virginia Tech, then ammunition and firearm type issues become a lot less important than the excessive length of the response time. And I guess I'd like to, very quickly, I know many of you sincerely respect the Second Amendment, and to suggest what has the Supreme Court said about this. I was on the oral argument team in front of the Supreme Court in District of Columbia versus Heller, and the court did not say that the Second Amendment is absolute in all respects, just as hardly anything else in the Constitution is absolute in all respects. And it did call out some identifiable types of legitimate constitutional gun control, and at the same time say that other kinds of gun control were not legitimate. What the DC case was about, of course, was a handgun ban. And we've had witnesses come in and say that in certain crimes, magazines of particular sizes were used. Absolutely true. But if you wanted to have a hearing on a handgun ban, you could have witnesses who would come in and talk about that, and the line would be 1,000 times longer. Handguns are, as a class, are vastly more used for bad purposes in crimes, including mass murders, than magazines of any particular capacity. Handguns are used in over half the homicides in the United States, the large majority of handgun homicides, and then you add in armed robberies and other handgun crimes, you're into the hundreds of thousands. And knowing all that, so the total damage of handguns in criminal hands is orders of magnitude larger than that of particular size magazines. And yet, the Supreme Court said you can't ban handguns because the court was saying you don't look only at the misuse of something because there is a right to arms in the Constitution. That's the point of that, is you take some of the legislative discretion away because we're making a permanent rule that some things are just off limits for how far you can go in restricting people's rights. And so the court said you can't, notwithstanding the large criminal misuse of handguns, you can't ban handguns because they are the type of firearm that is overwhelmingly chosen by law-abiding citizens for the lawful purpose of self-defense in the home. And we're broadly explaining why, in the court's view, the Supreme Court was right in 1939 to upheld a ban on sawed-off shotguns, that there's a distinction between what the line is for what kind of arms, and this would include accessories as well, are or are not within the scope of arms that are protected by the Second Amendment, is those that are typically used by law-abiding citizens for lawful purposes. And I'd suggest that the shift in this bill from 10 to 15 made a lot of progress in that direction in complying with the Supreme Court's interpretation, but there's still some room to go. If you look, 82% of new handguns manufactured in this country are semi-automatics. A very large number, a large percentage, have magazines in that 11 to 20 range. And of course, many of them, the Glock pistol with a 17-round magazine or a 19-round magazine, 17s, 19s, and 20s are typically used by law-abiding citizens for lawful purposes. The sales figures just show that. There are not enough criminals in this country, enough mass murderers or any other kind of miscreants to supply the market for these arms. For rifles, up to 30 is standard, not high capacity, not some accessory you buy afterwards, but the standard magazine that is made by the factory that you buy with the gun as part of the standard equipment. The AR-15 rifle for years has been the most popular best-selling rifle in the United States. There's at least 4 million of them right now in private hands, and probably a lot more based on recent months. The AR-15 comes with a standard 30-round magazine. Law-abiding citizens choose an AR-15 with a 30-round magazine or a Smith & Wesson pistol with a 17-round magazine for the same reason that those firearms are so popular with law enforcement, because they are good choices for lawful self-defense. And the Supreme Court says, you look at what people actually do. In a way, it's a kind of living constitution to say, well, what does the Second Amendment mean today? Look at how people actually exercise the right. And that's what the right is about. Not some theoretical thing, but the practical exercise. And for the practical exercise of that right, rifle magazines up to 30, handgun magazines up to 20 are within the Supreme Court's common use test. Obviously, this issue may be litigated eventually, but I'd prefer that it not be. And If this committee changed the limits to those I said, to 20 and 30, then I think, as someone who has sketched out this possible case, it becomes a much, much harder case to win, because can you say that 50-round magazines rarely used in crime? Yeah, but they're rarely used by anybody, partly because they're so unreliable. So it would be it's a more difficult argument to put them in the Supreme Court's common use test. And as one final point I'd suggest is, as Senator Giron said upstairs in one of the hearings, that the proper decorum in the Colorado legislature is to not impugn the motives of other people, which is a good rule. And I would urge that, as this debate goes forward and is discussed, that we not impugn the millions, literally, probably the tens of millions of people in this country who own magazines of more than 15 rounds. They didn't buy them because they want to be mass murderers. Maybe you think that they use them for target shooting competitions and you think that's not very important, or maybe you think the fact that they want a 19-round magazine for protection is they're being excessively cautious. I don't agree with that, but at least one can say that in a polite way. But to say that these are only made and only sold to people who want to engage in mass murder is really an inappropriate slander of tens of millions of law-abiding people. Thank you.
Thank you very much. Very interesting as usual, Mr. Kopel. You're always, I can see why you're a good professor, and I enjoy watching you on Friday nights on Colorado Inside Out. Senator King.
Thank you.
Thank you, Madam Chair. Professor, can you speak to the interest of Mayor Bloomberg and his interest in Colorado and specifically this legislation?
Well, it's no secret that Colorado, ever since the book Megatrends was published back in the 1970s, Colorado is a trend-setting state nationally, and Mayor Bloomberg, who has this very strong anti-gun agenda, has said publicly, it's not a secret, he said publicly that Colorado is his organization's top priority, because passing more oppressive anti-gun laws in New York or New Jersey, while an easy thing to do, doesn't really impress the national media or anyone else. And passing something in Colorado is seen as more of a trend-setting kind of thing. As an aside, I will mention one of my good friends, Richard Feldman, who used to work, he was an NRA lobbyist, and then he went to work for a Farmers Trade Association, with which his relationship ended unhappily, and so he, looking for a job, ended up working for Mayors Against Illegal Guns, and he was at the point of view that, of course, we should crack down on the stores, the bad actors, and have stronger enforcement against them. And he ultimately wasn't able to continue working for Mayors Against Illegal Guns because he would go to some of these stores in Virginia and say, this store, this particular one, is a model store. They're great, they're following all the rules, and not only following letter of the law, but they have very well-trained employees who are constantly on the lookout for straw purchases and prohibited persons and things like that. And he said, you can go back and tell that to Mayor Bloomberg, it's just like talking to a wall. This is not a guy who is a moderate gun control guy. This is a guy who just doesn't like guns, very much of his Medford, Massachusetts roots. In my friend Richard Feldman's view of the mayor, he certainly knows the mayor much better than I do, which is to say not at all.
Thank you.
Are there any other questions for Mr. Kopel? Seeing none, thank you very much for being here.
Thank you very much, Madam Chair.